APS is David White, our training program manager, joining us from the beach, it appears, but not really. And so he'll jump in if I miss anything too, and be a part of the discussion towards the end. Just very broadly, Adult Protective Services is the group within the Department of Health and Human Services that is responsible for protecting incapacitated and dependent adults from abuse, neglect, and exploitation, and protecting adults in circumstances that present a substantial risk. I think that that's a really important piece of what we do, that substantial risk of abuse, neglect, or exploitation, because we as APS can become involved if there's a suspicion that there's something going on. We don't have to wait until after something has happened for one of our caseworkers to go out and visit with someone. I'll also mention from the get-go, we're focusing today mostly on Adult Protective Services investigations, but within our APS unit, we also have our public guardianship program. So we have about 1,200 adults who are incapacitated, and the Department of Health and Human Services serves as the public guardian or conservator for those individuals. Very broadly, the APS is responsible for receiving, investigating, and determining the validity of reports of alleged abuse, neglect, and exploitation. The investigation process involves taking appropriate action at the initial stage if we learn that someone is unsafe immediately, making referrals for different services and arranging for providing for their safety, and also longer term actions, applying for services, connecting someone with the supports that they may need long term to be successful. And then as a last resort, petitioning for public guardianship or protective order if that's appropriate for someone who lacks capacity and is in need of that support. Just a couple of slides about the structure of APS. This is our general map of the districts of the Department of Health and Human Services. We have offices in several counties, and that they're broken up into districts. So in terms of our district-based staff, we have about 50 caseworkers who conduct APS investigations, and 8 supervisors who work in the district offices. We also have our Adult Protective Services Central Intake Unit based in Holton, 1 supervisor and 8 caseworkers who handle the 1-800 phone calls that come in from primarily mandated reporters. And then our staff handle the business hours calls. Child and Family Services takes over for the after hours Adult Protective Services calls that come in if you do happen to call after 5, but if it's outside the hours of 8 to 5, Monday through Friday. And then within our central office, myself, David as training, and then folks who are more on the public guardianship side with the state management and that work. Really getting into the definitions that are most important for Adult Protective Services to become involved in a case are the definitions for an incapacitated adult, a dependent adult, and then also, of course, what we consider abuse, neglect, and exploitation. So in terms of who qualifies for APS services, incapacitated and dependent adults, this little graphic here is really meant to demonstrate that all of our incapacitated clients qualify also as someone who's dependent. It's a much smaller group of individuals, and ultimately it's the court, the probate court, that has to make a determination whether someone lacks sufficient understanding to make and communicate decisions on their own behalf. We in APS have a lot many more options in terms of how we might go about assisting someone in and providing them with support if someone's incapacitated. The other category of clients that we work with are anyone who is dependent. So if someone requires assistance with their care or support due to any physical or cognitive limitations or needs, then they would qualify as dependents. So under our statute, anyone who lives in a nursing facility, an assisted living facility, receives services because they have a developmental disability, a traumatic brain injury, mental health services, all of those clients would qualify as a dependent adult. And an important distinction for us, whether someone's dependent or incapacitated, is that as an adult, even if someone's dependent, if they have capacity, they can tell APS, I don't want you involved, please go away. So that can cause some challenges for us, certainly, and we ultimately respect someone's decision if they decide not to work with APS. We try to leave the door open, letting someone know that they can call back if they change their mind, or letting them know what other services may be available to them, providing those resources if they are willing to at least open the door for that conversation. So all that to say, a major distinction, I think, especially for folks who are a mandated reporter for both child protective and adult protective, is what we see in child protective is really that safety above all else focus. And in adult protective, we really have to be balancing the autonomy and safety. And that can be a really gray area and a real challenge in some cases. In terms of the definitions of abuse, neglect, and exploitation, a couple points around this. We often see more than one form of abuse, neglect, exploitation present. So even if someone reports concerns about neglect, we're on the lookout for anything else going on. We see many situations where financial exploitation is reported, and it turns out there's a lot more going on there. So most of our cases, many of our cases, have more than one allegation present. And we also know that not every case gets reported. There are many reasons for that. And the more we are able to have outreach and people being aware of the kind of the red flags to be on the lookout for, the better. So in terms of what we would constitute abuse, it's any kind of, we break that down into physical abuse, emotional abuse, and sexual abuse. And an important piece I always like to mention is that abuse can be both an act or an omission. So if an individual requires assistance to get out of bed and a caregiver says, I'm not helping you out of bed today, that would be a failure to act, but it would also constitute abuse. Neglect is really failure to act can be failure to act as a reasonable caregiver, and also to failure to meet someone's basic needs, especially in a caregiving role. And then finally, exploitation is traditionally financial exploitation, but also things like medication diversion, lack of failure to get someone's informed consent, things like that. And I think an important piece, especially around exploitation, is that often people think of financial scams and the Nigerian prince or a romance scam or a lottery scam as being the main driver of financial exploitation. But what we really see as it relates to all of the types of abuse, neglect, and exploitation is that the most likely perpetrator is someone who is a family member or someone close to the individual. So something like 75 or 80% of our cases involve someone who's known to the client. Just providing a few statistics from past year in terms of the breakdown of the cases that we investigate. We do receive about 700 to 800 calls per month through our central intake unit. And a minor point here, but we've slightly changed our allegation categories because we moved into a new data system, but we still are capturing this breakdown, and FAST stands for Financial Abuse Specialist Team. So we do have a couple of caseworkers spread out throughout the state who focus on financial exploitation cases they have a little bit of training, a little bit more training than other caseworkers, and making requests to banks, financial institutions to review records, working with groups like the Office of Security and DA's offices and the Attorney General's office to try to prosecute those cases by gathering all the financial records that would support showing that financial exploitation took place. And again, of course, the percentages don't add up to 100 because we see that there's usually a combination of a few allegations going on at once.
There's a question in the chat about your collaboration or work with the Legal Services for the Elderly, if you are in collaboration with them.
We definitely are. We frequently work with Legal Services for the Elderly, especially when it comes to those financial exploitation cases. I think we did a study there was a study that Muskie School did a few years ago, and trying to kind of, they poured through a lot of APS data and Legal Services for the Elderly data to get a more complete picture of financial exploitation in Maine. You see many of the same types of reports that come in, and often if someone is just sold their house and doesn't realize it, the first call is going to be, let's get you connected with a lawyer, and Legal Services for the Elderly is a great resource. So yeah, all that to say, we work closely with them.
And there's a request to expand a little bit more on the when receiving mental health services, what it means when someone's a dependent adult.
So what we've generally, a lot of it is based on someone's living arrangement, and then the service, kind of the waiver services that we're familiar with. So if someone is living in a PNMI, for instance, or an assisted living nursing facility, or a home, a group home that is supporting people with developmental disabilities, sometimes just that factor is enough for us to qualify someone as a dependent adult, for us to go out and make that initial visit. There are certainly people who would not self-identify as a dependent adult, and they have every right to tell us, no way, don't get involved in my life right now. I don't know if that answers the question. Okay. Just turning to some risk factors that have come up frequently in APS cases, and I'll mention risk factors being different from red flags that we'll talk about momentarily, but just some factors that have been studied as indicators that someone is more at risk of being abused, neglected, or exploited. There are a couple of client-focused risk factors, particularly social isolation, someone who perhaps used to have a network of support and maybe friends and family have died or moved away. People who have diminishing capacity, such as dementia, and then living arrangement. And I was surprised to learn this not too long ago, but studies have shown that an individual who lives with one other person is more likely to be abused, neglected, or exploited than someone who lives alone. And I think that kind of ties into some of the other factors we'll talk about in terms of dependencies between a client and potentially a caregiver. What we've seen, similar, I think some of the same studies that have focused on risk factors for abuse, neglect, and exploitation, and particularly risk factors for older individuals who are abused, neglected, or exploited, or if they're living with someone who has mental health issues or substance use disorder. We're currently working with Muskie School to analyze APS data in trying to see how our information connects with the opioid crisis. Of course, there are some indications that if someone is dealing with substance use disorder, that might factor into their ability to be a caregiver, or if there are financial exploitation concerns there. But again, they're just risk factors. It's not an automatic, better get out there and investigate situation. And another perpetrator focus factor that that comes up frequently is dependency. If a caregiver is reliant on the person they're providing care for in terms of financial, a place to live, that can cause some real challenges and can be a risk factor for abuse, neglect, and exploitation. Switching gears slightly to red flags that may indicate that there is abuse, neglect, and exploitation going on. The first one on this list is the idea of a caregiver or someone who is taking over. Sometimes we think of that as a Velcro caregiver, the person who doesn't want the individual, the client, speaking alone with someone from APS or with anyone, a medical provider even. Sometimes that's well-intentioned, and sometimes it's I don't know what they're gonna say when I leave the room, so I'm gonna stay right here. Some other red flags we have identified are clients who are anxious, fearful, submissive around, especially around a particular individual, someone who no longer knows their financial status or indicates that they've signed things and didn't quite have someone explain it to them or understand what they were looking at. And then sometimes there are concerns related to kind of the new friends or someone who's appeared out of nowhere and is now the #1 person ready to be there for all things for an individual. Ultimately, we're always trying to pay close attention to the interactions between an adult and someone who's providing care to them or someone who's involved in their life. Interestingly, we frequently get calls through our intake line from bank tellers who are who've either taken an APS training or through our Senior Safe program or something similar, and they know their customers really well. So when someone comes in with someone they haven't seen before who seems to be directing that interaction, their antenna goes up and they make that call that something seems off for them. And for many of our older clients, especially who still bank in person, those bank tellers are very valuable in terms of catching some of that early on. In terms of some other red flags, I think a major one are changes. Changes in how someone is appearing, their overall mood, just behavioral changes in general. Someone who used to be very upbeat and is now kind of shying away from social interactions or events that they used to be excited about in the past. Those can be indicators. Another major concern are implausible or vague explanations on injuries. If someone's seeking care for a broken bone several days after what's happened, or the explanation for how that injury occurred just doesn't add up, that would be another red flag. There are some studies around things like bruising from the Department of Justice and trying to kind of get a sense of the location of bruising, the sizes of bruising that can maybe be attributed to things like medications or bumping into the coffee table versus being grabbed or hit. There are very few accidental injuries where someone gets a bruise on their face, for instance, statistically speaking. All that to say, the overall message around red flags is asking questions, really listening to those answers, seeing if what's being described makes sense, if the answer changes over time around something that may have happened, and then doing kind of the observing the surrounding situation and analyzing, does this add up to me based on what I know about this person or what they're sharing with me? There's no 100% surefire way to understand what's going on if there's abuse, neglect, exploitation, particularly if someone's trying to cover it up. But there are plenty of situations where you just have that gut feeling or those antennas that go up that that make you want to ask a little bit more or look into something a little bit more. Turning a little bit more directly to mandated reporting. If you take the mandated reporting training that's available on the APS website, it won't be nearly as much fun because you just click through, but there you do see the full list of the mandated reporter categories. And ultimately, there are several, especially medical professions, that are specifically required to report suspected abuse, neglect, exploitation to the department. And there's also kind of a catch-all category. Anyone who assumes full, intermittent, or occasional responsibility for the care of someone who's incapacitated or dependent, regardless of whether they receive compensation or not. So there are a lot of people, I would say, who are mandated reporters who have no idea that they are. But certainly, I'm guessing a fair number of folks on the call are social workers, and social workers would be one of the specifically named mandated reporter categories. This slide is really just a screenshot of the statute that applies to mandated reporting. And unlike child protective mandated reporting, APS mandated reporting requires that the person who has the information makes the report. It's not sufficient to say, well, I told my supervisor and they were going to make the report on my behalf. So we do expect to hear from the person who has the information directly calling our 1-800 phone line. There's also information directly in the statute about organizations don't have the ability to say, don't follow up as a mandated reporter. And we sometimes are working with organizations to make sure that their procedures don't conflict with someone's ability to make a direct report to APS, because that can be problematic. In terms of what does it look like to carry out the process of mandated reporting, the statute does require that mandated reporters call our 1-800 intake line, 1-800-624-8404. If someone's not a mandated reporter, there's also a online form that people can fill out. So we sometimes get anonymous reports through that, or family or friends of someone will report online. I generally encourage everyone, whether or not they're a mandated reporter, to make the phone call. Inevitably, the intake worker will have questions to clarify what's going on, so they can send as much information as possible to the district office. So having that phone call can be really invaluable. There's the link to that online form that I mentioned. And like I said a little bit earlier, that's available 24/7. You're speaking with an APS caseworker if you call between 8 and 5 Monday through Friday. And if you call after hours, on weekends, on a holiday, you're speaking with a child protective worker, but they've got the exact same information and it goes through the exact same system. Intake makes the initial determination. Are we talking about an individual who meets our definitions of incapacitated or dependent? And are we talking about a situation that would constitute abuse, neglect, or exploitation, or the risk of abuse, neglect, exploitation? They do that kind of initial screening to make sure that we have jurisdiction to get involved. If we don't, they may direct someone to speak to someone in a different agency. Sometimes we have people calling and they're talking about someone in New Hampshire, so we direct them to New Hampshire Adult Protective Services, things like that. So if it is something that's being screened in, meets those minimum requirements, then the next thing intake is doing is making a priority determination. We have 2 priority statuses. One of them is a priority where we would be going out within 1 business day at the latest to see the individual. And there are certain reasons why something would be a priority. Typically, someone's at risk of being abused, neglected, someone has been or is at risk of being abused, and the person still has access to that client. There might be evidence that we need to work with law enforcement to collect immediately, things like photographing bruises, or the scene of the crime, so to speak. And then if someone is in immediate need of medical assistance, or they need supervision or a caregiver and have none, then those would be priority cases. If it's not a priority case, then it's a case that will get assigned for a caseworker to become involved in within 5 business days. And another mention, just to mention around that, even if something is a priority APS case, we only have staff going out on cases during business hours. So if someone calls after hours, we're making sure that if there's an immediate need for someone to be protected, that 911 is being called or a welfare check's being arranged, because we don't have 24/7 staff to go out. We just have 24/7 staff to accept the phone calls.
I have 2 questions. One of them is about if it's the reports from another state, does that person making the report get the number for another state, or will Maine take the report and make that connection?
Typically, the intake staff person would say, you're going to want to call New Hampshire. Here's the number that you can call for New Hampshire, rather than passing on the information directly to the other state's APS.
And then the other question was mine, and I don't know if anyone else is interested in this, but I'm curious about the policy decision that for APS, the reporter must make the call, and for children, it's make the call or cause the report to be made. Do you know why there's a difference?
I don't know. I think it might have, my best guess is that the statutes were developed at different times and they didn't think that they needed them to be consistent, or it didn't occur to someone to check in on that. But I've had the same question also, and there are a couple other differences between child protective reporting and APS reporting that we probably should see about lining up over time, since the mandatory reporter groups overlap so much. But yeah, I don't know on that one.
The question with, I see Elizabeth is here. I didn't know if Elizabeth knew the answer.
I'd be happy to respond. You're absolutely right. They were written at different times, and we think of the APS standard as the direct report being where we want to go, and have advocated for years at the legislature to get the CPS statute to mirror the APS statute, both in terms of clarity for mandated reporters. You know, which one is it? How does it work? But then also, more importantly, so that we don't lose reports up the chain, which we know so often happens. But unfortunately, hospitals, camps, schools are very, very resistant to that direct report. They want to have an assistant principal, a hospital attorney, a supervisor at a camp in between the reporter and that report. We can talk about it another time, but the strange language in there about how you still have to make sure that the report is made by that other person, and you have to see documentation, or if not, then you're still on the line, is as a result of a compromise. It was as far as we could get with the CPS statute, but way to go, APS. We love it.
Thanks, Elizabeth.
Yeah, I know one thing that we talk about a lot is, for the most part, financial institutions are not mandated reporters in Maine, and we see that bank tellers have to report up to their corporate office, and so we're getting our call to APS through St. Louis headquarters, and we're like, well, we just want to talk to the person who knows what's going on, who saw them and can tell us the situation. So for many of our mandated reporter categories, it's really important that we're hearing as soon as possible from the person who knows, and can describe what their concern is. So once a case has been screened in by our intake staff, it makes its way through our electronic system to a supervisor in the county where the client lives. All cases that are screened in as an APS report are reviewed by a supervisor. There are certain categories of cases that a supervisor may close without assigning to a caseworker. The way our system is set up, each case is, even if someone is reporting on something that has already been reported, it comes in as a new case. So if something's already under investigation, it would be a duplicate, and a supervisor may close it for that reason, or something was recently investigated. There are a handful of cases where a supervisor calls the hospital, gets a little bit more information, and there's no longer a need for a full investigation. But close to 70% of the cases that get screened in by intake get assigned to a caseworker, and field investigation is initiated. Let me make sure I've got it. So in terms of the process for a caseworker, when a field investigation takes place, first and foremost, client safety. One of the first things that needs to happen is a face-to-face visit with the client to assess for their safety. Are they in any immediate danger? And if so, what needs to be done? So this has always been part of the process, but we really just formalized it in our data system with structured decision making, so that the caseworkers are really navigating what are the safety factors that need to be explored. And if someone is only safe with the plan, let's document what that plan really looks like. Is it a neighbor who's going to be checking in over the next day? Is it that call to legal services for the elderly that was immediately initiated? Things like that. So once we've established safety from the get-go, and we know that someone is currently safe, then the next step is identifying, are there services that could be put in place to make that more sustainable? And that way we're not setting someone up to be safe for a moment, and then we're going to get another call to APS as soon as we leave the picture. So the safety piece is really, sorry, I've just got these things popping up on my screen. The safety piece is one major factor, and then we're also conducting interviews, reviewing any records that may be pertinent to the investigation, so we can make a determination on whether the allegations can be substantiated. In all of our cases, we're going to be collaborating with many groups. It's more likely than not there will be another agency involved, whether that's law enforcement, the Division of Licensing and Certification, the Long-Term Care Ombudsman, Disability Rights Maine, etc. When we initially get a case that's screened in, we have an automatic process where we notify the district attorney's office for the county where the client lives that we have a report. And that is one way that we quickly connect with law enforcement if they're already involved in a case, if they've got history on a case. So we do see that happen frequently.
Are there any other collaborations or referrals that are sort of, for lack of a better word, like mandated or compelled in that process? Or is it all sort of case by case based on the needs and the safety plan of that individual?
I would say for the most part, it's case by case. If it's in a licensed setting, like a nursing facility, we automatically let licensing know. Their process looks a little different from ours. So in some situations, they say, go for it and tell us what you find out and loop back. But sometimes we do kind of side by side. Probably the one that we work really carefully around is with law enforcement. We never want, if there are concerns that there's a criminal element to an investigation, we don't want to go in and conduct that interview first and potentially cause issues for a future interview that needs to happen with a detective. So we sometimes are doing those interviews side by side where our caseworker sits in on an interview with law enforcement, or sometimes they tell us, hold off, we've got a criminal investigation here, and we'll let you know when you're good to go with your own investigation. But that's not going to change how we respond in terms of assessing a client's safety. It would just factor into how we're looking into the allegations to figure out what our findings are going to be on those. Just a couple more notes around investigations. I mentioned this before. But in terms of a client's capacity, we do have the duty to respect individuals' right to live in circumstances that are risky or dangerous. And that is largely driven by whether the individual has capacity to make their decisions. If there are questions about capacity, that's where we transition to what we call a guardianship study, where we're looking into, from a medical perspective, does this person lack the ability to make decisions on their own behalf? And do they need a public guardian or a private guardian to make decisions otherwise? That can be a complicated process and a challenging process, but it does come up in a handful of our investigations, but not all of them, or even close to maybe like 5% would be in that category. Ultimately, towards the conclusion of any investigation, we document all of our findings in our electronic system. Those are all confidential, I should mention. So we have a pretty strict confidentiality statute with some optional reporting categories, but we're not sharing records with perpetrators, for instance. And we are very careful to make sure that we're protecting the identity of whoever reported to APS. I know our caseworkers are very skilled in dodging those questions when they show up, and the first question that they get is, who sent you here? So that's something that we are always keeping private unless a court requires us to produce records, or someone like a guardian ad litem or court visitor requires the identity of a reporter, or law enforcement requires that information. The other piece around the substantiation process, and this is really kind of in flux, there was a change in statute just earlier this year, a bill that was passed. We have currently a database that's our perpetrator registry. And you can see in this kind of snippet of a statute that we have the authority to maintain a registry of perpetrators. So what we essentially have is a two-tier system, where if someone is a perpetrator of abuse, neglect, or exploitation, and the client involved has an intellectual disability or autism, we have authority to say this perpetrator is going to go on this list, and there are certain main care rules where employers providing main care services have to check our database to see if someone's on their list before they make a hire. That is great for cases where the client has an intellectual disability or autism. But we have many other dependent and incapacitated clients who are receiving care from individuals who may be perpetrating abuse and neglect and exploitation, and then can leave wherever they're working, or if they're fired because of the situation that led to an investigation, and they just go work somewhere else. So recognizing that as a real gap in our system, we approached the legislature about making that change, and that bill got passed. So now we're able to maintain, once we finish updating our rule and the statute's all good to go, we'll be able to maintain that registry for all of our clients. So people who are providing direct services what may end up on that registry if they perpetrate abuse, neglect, or exploitation on a client. So I think that's a really great development for our ability to keep people from bouncing around and continuing to abuse older people and people with disabilities. Just a couple notes on the guardianship program. As I mentioned, it comes up for clients who lack capacity. Ultimately, we're looking at, does this person require a guardian? So is this, and guardianship is always considered the last resort to protect someone. And a major piece here is that a guardianship study is often requested because someone is making bad decisions, but ultimately we're looking at whether someone lacks the ability to make decisions. So that can be challenging for some people who call and have concerns about someone, but it doesn't impact someone's capacity necessarily. And that is a frequent conversation that we have within our program. We're also looking at whether someone is in need of an emergency guardian and an immediate decision maker, or if we can go through the more standard process that can take several weeks or even a couple of months through their probate court. And we also are always trying to identify whether there are limitations on a guardianship that can be put in place. If someone needs a decision maker for medical decisions, but they are all set in terms of making their own financial or residential decisions, we can ask the court to craft an order that only provides us with certain decision-making authority. I think I saw, are there questions coming in?
There is a question for someone who came in later to review the risks for people who perpetrate harm. And I remembered 2 out of the 3. If you wanted to just quickly review those again, that would be helpful.
Yeah, so in terms of the risks that are perpetrator associated, that's what we're looking for.
Yeah, there was substance misuse and mental health sort of coupled, and then there was something underneath, right?
Yep, and that would be the dependency. So if someone is reliant on the client, then there's a higher likelihood that they may be a perpetrator of abuse, neglect, and exploitation, particularly where there's where you have the dynamic of someone's relying on an individual for their care, caregivers relying on the client for a place to live or finances. They need that check coming in each month to fund the whatever they've got going on. So yeah.
Great. And then I put in the chat, but I'll also put in a follow-up email tomorrow. About 2 years ago, Mikasa and Disability Rights Maine put out a 2-pager on working with someone who's under guardianship, because questions came up about access to advocacy and confidentiality. And so I put that in the chat.
And I'm glad you mentioned that, because I think we're really seeing a really positive shift around guardianship. There was a total overhaul of the Maine probate code just over a year ago, and the real focus is making sure that even if someone is subject to guardianship, private or public, that there's a focus on self-determination. Someone should be involved in making their own decisions, even if they have a guardian, to the extent they're able to. So what we see often is kind of this decision tree approach, where you want to make the decision that someone would make if they were able to. If someone's lived their entire life in Aroostook County, it's really wouldn't be appropriate for a guardian to say, it's more convenient for me for you to live in Cumberland, so I'm going to put you in this nursing facility. That's not the decision that individual would make. So that's the first step in guardianship, making the decision that the person would make for themselves, and encouraging, promoting their self-determination. It's really only when that decision-making would be really detrimental, harmful, dangerous for the individual that you switch into the best interests of the person mode. So I think that's just all that to say. The focus on self-determination, I think, is a really positive change that we're seeing directly built into the probate code when it comes to people who are under guardianship.
And we had a question about if there's a resource or a handout for choosing the right caregiver. I'm assuming that means like guidance for information not on the wrist, but sort of like things that affirm a safe and healthy caregiver.
It's a really good question, and nothing is coming to mind, but I'll take a note and bring it back. I know with the different programs, especially around self-directed programs, there may be some guidance that the long-term services and supports group within Office of Aging and Disability Services has available, or they might have some more resources. So I can get back to you on that one.
Great. And Dave's saying there's a brochure from LTCOP on this. I don't know what the LTCOP is, or do I?
LitCop, the Ombudsman, Long-Term Care Ombudsman Program.
Oh. We'll look for that.
And they are definitely a really good resource for a lot of things when it comes to particularly those licensed long-term care facilities.
And then I'm just checking a little bit on time, Erin. Do you know how much you'll need? It's 3:55. We're also interrupting you. I acknowledge that.
No, this is really the end of it. And I just kind of covered a lot of that in terms of self-determination, what we're looking for when we're carrying out our duties as a guardian. So I'm wrapped up. And the last slide, I have my direct line for my office, my email, and never hesitate to reach out. I'm always happy to answer general questions, talk about a case. If you've made a report and have questions about what's going on, I'm readily available.
Thank you. And Elizabeth's chiming in. Apparently we had a booklet at some point, which is probably where the question came from, that it was floating around an agency. So I'm going to look for that. And maybe other folks will as well. Are there any questions specific to Erin and this APS training before we click off the record button? I got a fabulous. Thank you so much. All right, I'm going to pause